This video is going to discuss some possible future uses that you'll see of Calder. And if you remember from class, we've discussed how the court used essentially a test to determine whether libel used through an indirect medium into another forum could constitute minimum context in those forums. And we saw a fracturing of lower court opinions after Calder between the focal point and effects test. And so this video starts us from that perspective. And one future area that you'll see the use of Calder in is in the context of internet contacts. And I want to spend just a little bit of time in this video giving you a little bit of background about where we started with internet contacts and kind of where we've arrived. Our framework essentially is this: should we treat internet contacts differently from other indirect contact with a forum, such as mailing a letter to a forum, making a phone call to a forum, shipping a product to the forum? In each one of those activities, you see someone accessing the forum or residents in a forum, but through an indirect method. The internet is essentially that, where an individual is contacting residents in a distant forum through an indirect method, that of the internet. Is this method one that we should treat distinctly? There is no United States Supreme Court decision specifically on internet contact, and most of the early decisions about internet contacts from the lower courts have been fairly highly criticized. There's one important one I want to give you a little bit of information about, just to give you context for when you get out and practice, but we're going to talk about where we've come from here. So this case essentially was called Zippo, and it is a cyber squatting case in which the court discusses internet contacts and how to treat them. The court here focused on the level of interactivity of the website itself. Now, in Zippo, you have to understand that the lower court was writing without a lot of direction. Of course, there was no United States Supreme Court case on how to handle these kinds of contacts. And it was also in a time in which the internet didn't operate like it does today, or internet contacts were different. So this is the early to mid 90s that you see this case come out of. And basically the court in Zippo said, well, we can break websites up into things that are purely passive, one in which the user of the internet was trying to access, members of a different forum or different state by posting things, and there was no response, no interactivity from someone viewing the site. So if you want to think about it, it's akin to putting your thoughts out on the web page or putting up a blank advertisement on the web page with no interactivity by someone viewing the page. They can't access you, there's no way to email you, no way to contact you. The court in Zippo said that kind of posting, that kind of internet page would not be purposeful availment of a distant forum. The other end of the spectrum that Zippo pointed out was when you have a very active web page, and these are the kind of pages in which there is a lot of interactivity between a user of the page and someone initially posting things on the page. So if you want to think now, Amazon.com, so you've got goods for sale, there's lots of ways to contact them. They'll send you messages, they link and talk to you throughout, in the sense of getting information from you and making sure that your sale goes to them. So it's a very, very active page. They also said, in those, they said there would be PJ. They also said there's a middle category, those that are interactive, where there's some discussion between the original poster and a user, but that is not the same level as having a web page that's completely designed with the full intent of having interaction with someone in a distant forum. And unfortunately for Zippo, they said, well, with these ones, there might be PJ, there may not be PJ, that might constitute minimum contacts, it may not, but it's sort of in the middle. And in the early to mid 90s, that's sort of workable because most web pages are either in the very passive or the very active, and there wasn't so many in interactive. But even then, it posed a bit of a quandary. Why is it that a purely passive site should avoid personal jurisdiction? If I posted a libelous page and someone in a distant forum that where it was very clear that the libel would cause harm, where the libelous content maybe was found some connection to that forum, why should it be that because I used a purely passive web page that would not constitute minimum contacts? So even in the context of Zippo and what the internet looked like at the time of Zippo, the test still kind of left a little bit to be desired. And so what you have post Zippo is a lot of courts using it, and I put adopt in quotes because there really wasn't much out there. So at least having some discussion of let's look at the website seemed appealing, and so you had a lot of circuits initially doing this. But there was many that said Zippo is it's not helpful. It doesn't tell us in the end much about minimum contacts, or not a lot could be inferred just from interactivity of the web page. Today, like recently in 2010, the Seventh Circuit expressly rejected using Zippo at all, but you will find a lot of courts that still like to cite to it, but most tend to require some additional evidence of purposeful availment beyond just how interactive is the web page. And I think that's for two main reasons. One is most web pages are fairly interactive. And secondly, even if it is a passive web page, that shouldn't mean automatically that there's no purposeful availment in the forum. It just means, we need to look to more things. So if you think about it, most circuits are going to say, all right, if we cite to Zippo, let's just talk about interactivity, but then let's think about what the claim is regarding the internet usage and then use the appropriate tests for those kinds of claims. So if the contact over the internet is in a personal agreement or a contract, then let's use Burger King. If the internet is allowing for distribution of an unsafe product through a stream of commerce type of sale, then let's use the stream of commerce cases. So what you're seeing mostly is you'll still see references to Zippo, but a lot of courts are requiring more than just that. Internet context plus, if you want to think about it. And one of the most predominant ones when you see the internet is Calder. And I think that's in part because, the internet has a way of providing for a lot of intentional tort claims, such as libel, to occur. Also, I think the Calder test about where the focal point or the effects kind of test suits a lot of these well. Here's an example that is not Calder, just to kind of show you how to use the internet context plus, or see how you use the internet in a case, a context that we've already seen, and that is of a contract dispute. So this is a real life case. We've got AHL is a California corporation with its principal place of business in California. It operates Casino Royale on the internet and advertises it as the world's largest internet casino. The server is in California, but the website can be accessed from anywhere in the world, not uncommon to most websites. Once a player accesses the website, he or she can agree to play poker, blackjack, or roulette by using their credit card. Tom, a Texas domiciliary, accesses the website and wins $193,000. HL refuses to pay the winnings. Tom sues HL in Texas. Is there personal jurisdiction over HL in Texas? And so even if, for example, in answering this question, even if the court was to use the Zippo test about interactivity, I think this one is a highly active web page, we'd still want to consider, well, what is the paradigm that this case comes out of? What kind of claim do we have? What kind of PJ test do we typically use for these kinds of claims? And then decide whether or not we actually have personal jurisdiction over HL. So if you think about it, this one is a breach of a contract. I agree to play a game. Under the terms of this agreement, you will charge me a certain fee on my credit card, and then if I win this particular game, I'm entitled to receive the winnings. And so when they fail to play the winnings, they've breached the contract. And so even if we ran Zippo, we'd still want to consider Burger King and say, look at those factors under Burger King about contacts, prior negotiations, the terms of the actual contract, future contemplated consequences, actual course of dealings. Of these kinds of contacts, uh, what would we think is their minimum context or purposeful availment in Texas? And I think with this kind of a contract, I think you would find that reaching out to someone in Texas who basically, there's not a lot of negotiation and there's not a lot of long-term potential use of the web page, but certainly I think it would not be unreasonable for a defendant like HL to be hailed into a court in Texas when they breach on a specific user's contract with respect to awarding winnings. All right, so it's not as strong as Burger King, but certainly one in which I think it wouldn't be unconstitutionally unfair. So this is just to give you a context about where we might see Calder go in the future, where we might see internet contacts in general go in the future, and we'll pick back up on this in class as well.